Hi everybody, Dana Sparks, broker of Maximum on Greater Atlanta Realtors, and this week's contract tip has to do with commission. How do you as a real estate agent get paid? Well, let's start from the beginning. Where does the commission initiate? It all initiates with a public seller, and a seller contracts for commission with a listing broker, and that's done on a listing agreement or on an authorization to show unlisted property if it's not being listed. And then a listing broker contracts to pay a selling broker a cooperative commission if the selling broker is the procuring cause of sale for that transaction. Then, just parenthetically, how do you as an agent get paid? Where is that? Where's the contract for that? Nope, not commission instructions. Nope, not the listing agreement. Nope, not the buyer brokerage agreement. Those are all contracts. The buyer brokerage agreement and the listing agreement are all contracts between the public buyer, public seller, and the broker. And the commission instructions are the written agreement between the listing broker and the selling broker. The contract where you get paid your commission is in your independent contractor agreement. So back to the topic at hand. So public seller contracts to pay a total commission with a listing broker, either on a listing agreement or authorization showing listed property. It's all described there. And then as a selling broker, as an agent working for the selling broker, how do you know when you show a property what you're going to get paid as a commission if you are in fact a procuring cause of sale? Well, that is communicated to you via the MLS system, either predominantly here, FMLS or Georgia MLS. We do have a variety of other MLS systems, but predominantly those MLS systems. So on FMLS and Georgia MLS, there is a place where it talks about the co-op commission, what you can reasonably expect, what your broker can reasonably expect to get paid if you are the procuring cause of sale for that transaction. In other words, if you have a buyer that buys the house and you go to a closing. So what happens if that co-op commission, you don't actually get paid at closing, or on the closing statement, that closing commission isn't what you thought it was going to be from the MLS service? Well, what is that all about, and what can we do about that? Well, let's back up. Let's see what license law says. Well, license law says it is under OCGA 43-40-25B, subparagraph 35, that it is an unfair trade practice to induce any person to alter, modify, or change another licensee's fee or commission for real estate brokerage services without that licensee's prior written consent. Now, that being said, we all know that any terms of any contract may be amended in writing and signed by all the parties. So the parties can change their agreement for the commission on a written document. But how is it that you as a selling agent or a selling broker first find out about the commission? Well, in the MLS service. So the listing broker will put in the MLS service, as I mentioned, how much the co-op commission will be to a selling broker. Now, Georgia MLS defines a multiple listing service as a facility for the orderly correlation and dissemination of listing information so that participants may better serve their clients, customers, and the public. Further, it says an MLS is a means by which authorized participants make blanket unilateral offers of compensation to other participants. Georgia MLS does state, and you'll notice in FMLS too, there's just a place for a co-op commission. There is not a place for the total commission. There is not a rule that the listing broker is required to disclose the total amount of commission that a listing broker is being paid. And there are no rules, laws, regulations that indicate that a listing broker is required to share the commission that a listing broker gets with a selling broker in a 50-50 division of that total commission. The listing broker is allowed to offer whatever portion of that total commission to a selling broker that they agree to offer. Now, in the listing agreement, in the GAR listing agreement, which is GAR F1 exclusive seller listing agreement, in paragraph A6 and B6B, it does have the total commission that the seller is paying, and then in the GAR listing agreement, it has a portion of that total commission that the listing broker agrees to pay the selling broker should the selling broker be procuring cause of sale. And of course, the listing broker and the seller sign that listing agreement. So any changes to that would have to be addressed in a special stipulation to that listing agreement. Now, in the RE Forms listing agreement, which is RE 151, it just states broker compensation. Seller agrees to pay broker a sales commission of, and you have a certain percentage of the sale price or a flat fee. In the event that during the term of this agreement, the broker or any other licensee procures a person ready, willing, or able to purchase the property for a price not less than, and it's an agreed upon price, or seller enters into an enforceable contract for the sale or exchange of the property with any buyer without an exclusion set out in this agreement as to any buyer, whether by or through the efforts of the broker or any other person, including the seller. In the RE Forms listing agreement, there is not a section where the seller agrees to the compensation of a selling broker by the listing broker. So that's a big difference between those two listing agreements. So based on that, again, a listing broker will advertise in an MLS service what the selling co-op commission will be for a cooperative sale. And in an article about procuring cause of sale by Seth Weissman, now this was back in 2001 when Beretta laws first came into effect, but nevertheless, he does state that, and Seth Weissman, for those who don't know, is the legal counsel advising behind the Georgia Association of Realtors Forums Committee. And it does state that listing a property on an MLS does constitute a contractual offer to cooperate with all members of that MLS and to pay them a specified commission if they are procuring cause of sale. However, if a property is not listed in an MLS, the financial basis upon which the selling broker will be compensated needs to be worked out in advance. So, additionally, on the printouts, it does state that accuracy of all information is deemed reliable but not guaranteed and should be independently verified. We all know that there are mistakes, a variety of mistakes that appear in a listing on MLS and Georgia MLS on the printouts. Nevertheless, if you're a selling broker, I'd strongly suggest that if you have a buyer that's going to write an offer on a property, you go ahead and print out and keep in your file how that listing appears in FMLS and Georgia MLS on the date that you are writing the offer. Now, also on the MLS services, you will see a box that says VRC. That stands for Variable Rate Commission. And if there is any possibility whatsoever that the commission offered to a co-op broker could change, if there is any sort of possibility of a variance in that commission, that box really needs to be checked, yes. And then FMLS states that if there's a possibility the selling commission might be different than what's listed in the selling commission field for any reason, you should put an asterisk, and then in the private remarks, put an asterisk and explain the explanation of how and why that commission might be a different amount. In the variable rate commission, you really should put yes if that commission has a possibility of changing for any reason. Either for, if that's going to change on a certain circumstance, that should be marked yes. The other reason you really want to mark that yes is to indicate if there's a possibility that you have a competitive advantage if you sell the property without another agent. For example, let's say that the seller and the listing broker agree that should no other broker be involved in the sale of the property, that the total commission the seller will pay will be something other than the total commission the seller would pay should there be two brokers involved. And again, on the listing agreement, that would all be explained and agreed upon in writing on the listing agreement as a special stipulation. But if that's the case, then you listing brokers, you need to mark yes under variable rate commission, because there is a circumstance under which that commission could be varied. So you need to make sure that that is marked correctly. So what do you do as the selling broker? So the listing broker, you already have it in writing from the seller on, the listing agreement or authorization to show unlisted property. So what do you do as a selling broker to protect yourself and your commission? Well, don't rely 100% on what the commission shows on an MLS printout. Again, we've already mentioned mistakes can be made. You need to verify that. So how do you verify that? Well, you want to get it in writing, signed when you're making the offer. So in the GAR contract form, there is F32, instructions to closing attorney, and that is a contract, is a form signed by the listing broker and the selling broker, or the affiliated licensees of those brokers. And that's where the commission is clearly delineated, described, and addressed. When you are writing an offer for a buyer, you selling agents, you need to fill that out at the same time and submit the offer, submit both of those to the listing broker, but not as a package, because again, the commission contract is between the brokers and has nothing to do with the contract between the seller and the buyer. That's why it's no longer in the contracts. But I would prepare both of those documents and send them as separate attachments to the listing broker. The purchase and sale agreement, so the listing broker can present that to the seller, and the commission instructions so that the listing broker can sign it and get it back to you. In the RE forms, it's RE Form 115, Commission Acknowledgement. Do not wait until right before closing. You guys, get that signed up front in advance. Now, there is another form that in a GAR form that you may use. It's GAR F38, Co-op Commission Agreement, to be used prior to showing. Now, you definitely want to use that if the property is not in an MLS service, because if it's not in an MLS service, there is no contract at all regarding what a selling broker agrees is going to get paid for being procuring cost of sale for this transaction. Might not be a bad idea, selling agents, to go ahead and present that to a listing broker prior to showing the property. Bottom line is, if there are any discrepancies between what a selling broker or an affiliated licensee of a selling broker thinks they are going to get for compensation for the contract as commission, and what's agreed upon in one of these forms and what's marketed and advertised in one of the MLS services, you need to get all this squared away up front. FMLS and Georgia MLS do not get involved in these disputes. This issue would be addressed between you guys as agents first, and then by your brokers, and then if there's no resolution, it would be handled potentially based on your broker more formally, either with arbitration or with litigation. But don't even let it get to that. Address these issues up front and make sure that the listing broker, when you first put a listing in an MLS service, go over how that listing looks. Make sure that all the information is correct, not only with respect to the property that you're marketing and advertising and selling, but also with respect to the co-op commission being offered to a selling broker. And you selling brokers, check that and then go one step further and get it in writing on an additional form, the actual contract between the listing broker and the selling broker for co-op commission. Thank you guys so much for watching. I hope this contract tip helped you out. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.